So it doesn't look like, I think it's slowed down. So it doesn't look like anybody else is going to be joining us, at least for now. So we'll just get started. Good afternoon. Thank you for joining Danielle and me for this workshop on addressing tech-enabled abuse in your cases. Our focus is domestic violence and sexual assault cases. And one thing we realized through the work that we do is that technology is not only an opportunity to connect to the larger community, it can also become a source of coercive control and stalking and abuse for survivors. And so we wanted to really focus on that issue for this workshop. For any of you who attended the Access to Justice conference last week, Danielle started an in-depth dive into tech-enabled abuse. We call it tech as in TECC, tech-enabled coercive control. That was part one. This is sort of a continuation of that workshop. And then actually, Danielle, before I introduce myself, do you want to introduce yourself?
Yes, thanks, Rudy. I'm struggling with my own technology over here, trying to make sure I can admit people and get all my screens taken care of. So you'll notice that we do have closed captioning when I'm talking only. So we'll have the benefit of that for the part of the presentation that I present. Unfortunately, we couldn't get it together for when Rudy's talking. So I'm Danielle. I've been with SVLC for a little over a year and a half now. But prior to that, I've been in some capacity working in at the intersection of tech abuse and violence against or gender-based violence for probably close to 4 years in total. But before this, I was at the Department of Labor. So I'm really excited. This is also still going to kind of be a brief overview of some of the evidence components and admitting evidence of tech-enabled abuse. And a huge part of what we're going to get into actually comes after doing safety planning with survivors. So if you weren't there for the training last week, it should be up on the Access to Justice YouTube channel soon, but we'll also have our own link and it'll be up on our YouTube also soon whenever we get the link. So please let us know if you didn't see that and would like to see it. And for those that did, thank you for coming back and having another training with us.
So Danielle, thank you for the introduction. Do you want to just go to the next slide and we can start talking about the program? And for any of you who don't know me, I'm Rudy Mukapade. I'm the director of the Sexual Violence Law Center. I've been with the program for about almost going on 10 years. And prior to this, I was a baby public defender. And before that, I was with the Northwest Immigrant Rights Project. So talking about the Sexual Violence Law Center, we, many of you are already familiar with the program, but for anybody who's new to our workshops, we are a small nonprofit law firm that focuses on providing holistic legal assistance and representation to victims of sexual violence, which includes abuse, harassment, stalking, rape, and trafficking throughout the state of Washington. By holistic, we mean we will assist or represent the survivor in all the legal areas connected to the sexual assault, with the exception of personal injury. That is not an emergent civil legal need. And there are many members in our community in the private bar who more competently can represent survivors in their personal injury cases. And with family law, we provide consultation and hotline level services, but we do not provide full representation. We represent all ages, all genders, all identities. The main thing to identify, to qualify for our services that is needed is that the person identify as a victim or a survivor of some form of sexual violence. We are also doing this CLE series in partnership with the South Asian Bar Association of Washington. Saba, and for members from the Saba group who are here, thank you for joining us. We hope you will be taking pro bono cases from us soon. Also a reminder that many of us identify as survivors. Many of us work with survivors, not only in a client capacity, but also as colleagues. 1 in 3 women will experience sexual violence in their lifetime, 1 in 6 men, and 1 in every 2 non-binary and gender non-conforming persons will experience sexual violence in their lifetime. So to be mindful of the questions that you ask and the comments that you make related to these cases. And with that, that's our formal introduction. Jumping into the topic, we want to talk to you about tech-enabled coercive control. So Danielle, do you want to go to, yes, the next slide. This slide, we, for a few years, advocates in the community had been identifying how technology has become a source of continued abuse and stalking for survivors that we work with. I think for any of us who have been in the field for a while, maybe we didn't have the language to describe it before, but what we were seeing were patterns in the community of how tech platforms are used against survivors and become another source of control, another source of stalking, another source of abuse. So the tech working group was started locally by UW and Seattle Advocates. The focus had been to help identify patterns, collect information, and it actually led to the publication of a white paper report. The work is now being housed at Sexual Violence Law Center, and we have renamed the work as as TECI, the Tech-Enabled Coercive Control Initiative. And the goal really is to increase our understanding across all sectors, including law enforcement and the technology industries, to really help create better tools that assist survivors when they are experiencing tech-enabled coercive control or tech abuse. Focus on more research to really highlight survivor experiences and amplify survivor voices, develop recommendations, working not only with law enforcement, prosecutors' offices, the legal system, but also technology companies and platforms on how to better respond to the needs of survivors who are experiencing tech abuse. And so the reason for this is because of the kinds of cases that we see. And these are cases that many of you are already probably familiar with or may have even experienced yourself. The most traditional sort of idea that the most traditional tech abuse cases that people do identify are the ones related to the distribution of intimate images, non-consensual intimate images. And we've seen this with the recent case of Representative Katie Hill from California, who stepped down once her ex actually disclosed her sexual history and also images of her that she did not consent to being distributed. But we also see other types of cases. Danielle, do you want to talk through some of the other types of cases we see that are tech-based?
Yeah, thank you. Sorry, I couldn't find my unmute button with everything on my screen. So we see plenty of examples of these, and increasingly we're seeing more and more as people are going or being forced really to be online with the pandemic. I could give a bunch of examples. I know another celebrity example is Carrie Goldberg, who actually is a sexual violence attorney out in New York, who faced sextortion, which is the sexual extortion when someone, blackmails a survivor with a threat to disseminate their intimate images or to dox them if they don't behave in a certain way. But Carrie's one of the lucky few that actually was able to handle their own or her own legal representation, and then ended up starting a law firm based on that, and is one of the biggest law firms that fights for survivors of sexual assault and sexual harassment online. One of the bigger things that we see is the intersectionality of some of these, of some of the bigger legal issues that we see. So I would highlight the third example there, where an abuser might exploit the victim's immigration status, send spoof sexual images, and cut family ties, or make it so that the immigrant is completely isolated. And I wanted to highlight that one because we're not always talking about someone who has a supportive family or somebody who has a lot of resources like Carrie Goldberg, or somebody who knows exactly where to turn when something like this happens. You might be dealing with somebody who has severe mental health issues, and as soon as they are hit with something like this, their paranoia heightens to a level of no return. And so you have to take an intersectional approach and a trauma-informed lens, which is what we try to do at SPLC, and understand that this is just one of the harms that comes from this kind of sexual violence or domestic violence and stuff. Okay, I was gonna say next slide, but I'm handling this slide, so bear with me. If you wanna hear examples of any of these other types of case profiles or any of the technology abuse that we talk about, just put it in the chat. We have plenty of examples.
And I'm sure in the audience too, that there are examples that you have that you might be able to share as well.
Absolutely. So obviously it's going to be important to talk about the differences between what we might consider traditional coercive control and tech-enabled coercive control. So physical violence is clearly a traditional keystone. That's what is the foundation for a lot of the statutes that we have. There's a lot of imminence with that. There's a lot of direct physical evidence, for example, a black eye or bruises around someone's neck, that a court will take more seriously just based on the immediacy of it. Threats you usually see face to face, or someone will actually hear a person, an abuser, make a threat towards someone else. Sexual violence, culturally, socially, we have that traditional ripped gown, and I'm gonna say some things that could be potentially triggering, and we didn't make that disclaimer initially, but we're talking about sexual violence here, so there may be things that are triggering, and we do apologize about that. But just so anybody on the presentation is aware. So the traditional sexual violence, physical things that you might see, again, are bruising. And the movies will tell you that it's a ripped dress and blood running down someone's legs, or something really dramatic like that. Monitoring, and I'm not going to go through the entire list, but monitoring and stalking, I've literally seen someone walking and stalking someone on the street corner and trying to hide their face like this. So those are things that are happening in the physical world as opposed to the virtual world and what we're used to. I highlighted crazy making and gaslighting just because here's where even in the non-virtual world, I think that judges and courts and attorneys generally have a hard time with this one, but it's so prevalent and so rampant. Every week we'll see a response to a protection order petition where the respondent will say, "Oh, they're just crazy," or they're experiencing postpartum depression, or they're just anxious or depressed, and they're just crazy, and so you shouldn't believe them. They're unbelievable. But a lot of what we're seeing a lot of the physical and the virtual or tech-enabled cursive control really does cause people to experience extreme stress or extreme anxiety to the point that it actually has a physical impact or changes the chemistry or the emotional makeup of the person. So it actually does make them seem crazy sometimes. So keep that in your mind when you're coming to assist survivors from a trauma-informed lens. So when we move over to the tech-enabled cursive control, that's where we start to see the abuser take a little bit of a step back in a way, as in they're not directly in front of the person sometimes. And it just starts to become a little bit harder to notice from an outsider looking in, but it's still just as real to the survivor. Tech companies themselves that are developing these apps don't have what some researchers are calling survivor-based threat modeling, which is where they're creating the Internet of Things. They're creating apps that are supposed to be helpful, where you can track your kids on their way to and from school to make sure that they're safe. Some of these things are being used to contribute to virtual stalking, which, if you're looking at someone's Alltrails app that's being uploaded to the cloud, or if you're looking at your child snapping where they are and you know that they are with their survivor parent, you can easily go and monitor that person's whereabouts or their location. Phishing is one example that's not up here, and that's the fraudulent practice of sending emails purporting to be from reputable companies or people in order to induce individuals to reveal personal information, such as passwords and credit card information or numbers. And that's just another form of tech-enabled cursive control that's actually not listed here. So I wanted to really quickly go back to the crazy making and gaslighting and give a specific example of how, again, that intersectionality happens. So I had a client who their abusive partner was generally physically or emotionally abusive, but also had a huge following on social media. They had over 10,000 followers on their Instagram, and would guilt trip the survivor into doing these polls on their Instagram. And so if you have ever used Instagram or about Instagram, there's an opportunity, or there's an option to create a poll on your stories. And it essentially is a question posed to your followers that asks them to respond yes or no, this or that. And so there's only two options or two ways to respond. And he would post maybe 30 or 40 of those every day or every other day, and guilt trip the survivor into responding to them. So she would sit there and have to select yes or no, this or that, A or B, for months, until she had a nervous breakdown. And when she came to out of the behavioral health therapy after the nervous breakdown, she still had problems making decisions, where this person was a solid decision maker prior to this incident. But all of this stress amounted to permanent damage to the frontal lobe, which is an actual diagnosis that impaired her ability to make decisions. And so that is one example of how someone will be able to cross, non-tech enabled cursive control into tech enabled cursive control, and have, other impacts outside of the abuse itself, like a permanent mental health condition. Things to think about when we're talking about the real consequences of some of this stuff. So we're going to get into a little bit of how to collect evidence and what to do with that evidence once you have it, if your client or the survivor that you're working with actually wants to go and litigate some of these things. So up here on the screen are some of the most common day-to-day apps that you're most likely familiar with. I'm not even going to say most likely, I take that back, that you absolutely are familiar with, that you're using every single day. Text messages, direct messaging apps, voicemails, social media is a huge one. Again, we actually, as Reedy mentioned, we serve multiple age groups, or all age groups. But when you're talking about social media, that's one, and I'll get into this a little bit later, but that's one that is really impacting minors a lot more than it is impacting older generations right now. If you have seen, or if you know of other places that you've collected evidence of technology-enabled coercive control or tech abuse, please feel free to put that in the chat. We're always wanting to expand. There's just only so much that you can put on the screen. Okay, so part of the reason for this presentation is that the current response is not the best and might even be considered outdated and bad advice. We do generally think that the law is catching up, but we still every day see investigators, lawyers, and judges especially still a little bit behind. And here's an example from the AG's office website with a tip on how to respond to cyberbullying. One of the tips is to just block the person. And we've even heard, one of my colleagues who's on the line today had a case where the judge literally just said, can't you just block this person? And, you know, maybe when we didn't really understand technology or how pervasive it can be, that might have been good information or good advice, but now it isn't. And we actually have rules that criminalize some of the stalking that goes on online. So for us to still have the courts suggesting that we just block someone is akin to telling, you know, a person who was raped that they should dress less provocatively or they should dress more modestly. So you can see how some of these legal responses are a little bit outdated. And when a survivor goes and reports some of this and says, yeah, I can block them. I've blocked them 20 times, but they keep creating fake profiles or keep, you know, finding other ways to find me, then you can see how it's really ineffective.
And if I can add here, Danielle,
yeah,
like
go ahead.
the other thing is that this is where I think some of the outdated advice is problematic because it puts the burden back on the survivor to have to like somehow avoid the abuse. That's
Right.
one problematic aspect of it. The other thing is it ignores that a lot of times these tech identities, these email accounts, these social media accounts are very connected to not only the survivor's social network, but sometimes their professional network. So, for example, if I am constantly being bombarded in my work email by somebody who's threatening me, stalking me online, harassing me, trolling me, and the court is just responding, or the AG's office, for example, here is saying, well, just change your email address. That's now connected to my livelihood. That's connected to my professional identity. And so some of this advice is also just not actually feasible or helpful in any way. And it's the turning the other cheek kind of response that we know is based in sort of victim blaming and rape myths. And now we've just kind of taken it to the online version. So sorry, I just wanted to add that before we moved on.
No problem. I should have mentioned that. Rudy, please jump in whenever you want to elaborate on anything. So before I move on from this one, I would just say that law enforcement does still lack some of the resources and protocols or priorities or education generally to pursue some of these cases. So if you are working with survivors, it's going to be important for you to assist them, be vigilant about the laws and regulations that do provide more support to them, and actually educate the bench and educate law enforcement about how to go about that. And we'll talk about that in a little bit more detail later on. Okay, so now we'll get into a little bit more of the nitty gritty, like we promised earlier, about tech-related laws and getting evidence admitted. But before we do that, I just wanted to reiterate the safety planning component and the investigation planning component. And point again back to the access to justice training that we did last week called Deadly Technology, where we actually went step by step on how to talk to a survivor about whether they even wanted to take a tech abuse case or a tech-enabled coercive control case to the next level. The biggest thing is that sometimes survivors don't want to see the perpetrator again. They don't want to hear the respondent. They don't want to be in court with them. They just want to cut ties and be done and secure their safety and secure their information. So if that's the case, then the rest of this presentation does not apply to that, to your work with that survivor. So it's important to realize that this is coming from a part in your case where you've already decided and talked with your survivor about pursuing some type of litigation. Okay, let me go back. So can you all see the tech-related laws on your screen? Okay. So here are some of the laws, criminal and civil, that are available in Washington and elsewhere. Most often, our office is responding with protection orders, seeking to restrain further abusive behavior or non-consensual distribution of intimate images. But again, these are some of the civil and criminal remedies that are available. If you work in any of these areas, as for example, if you're a personal injury attorney and you want to work with us to take on a defamation case, we're always looking for pro bono attorneys to take it a step further with some of our survivors. We do tackle some of these, like copyright. We will file a copyright on behalf of a client and assist with the first takedown notices. And what that looks like is, you might have a survivor come to you with a complaint that their ex is threatening to post nude photos of them on the internet, or myex.com, which was actually recently taken down. And so they'll actually have the image on their phone because they took it and sent it to the respondent or the perpetrator at some point when the relationship was going well. So you might help them file a copyright or a trademark over that photo. And what happens then is the DMCA, the Digital Millennium Copyright Act, will actually acknowledge a copyright and send a takedown request, or actually take down an image that's been posted without permission or without the copywriter's permission. You might also be able to have more teeth when you send a cease and desist letter or a takedown notice directly from your office, and be able to cite to the copyright protection or the trademark protection that you have. In the past, it was such that an image was copyrighted or a work was copyrighted as soon as it was created. But in order to have any legal bearing, you do actually have to file for the copyright protection or the trademark protection and actually have it registered. And I think that some of those rules have changed recently. So before you do any of that, please do look it up or consult with us. We do provide tech assistance to attorneys and advocates. Any questions about any of these? I'm not monitoring the chat, but Reedy will be able to give you any specific RCWs for any of the criminal or civil laws that are listed up here on the slide. So before I move on from this slide, I did want to just mention how these regulations here, are laws on this screen, primarily relate to when the survivor wants to make a claim, file a claim, or press charges directly against the abuser. But some victims in the past have attempted to go after the middleman, who in their view helps facilitate the abuse. So unlike physical abuse that we're talking about traditionally, tech-related abuse or tech-related, tech-enabled coercive control usually has additional parties that you might not think of initially. So you're talking about the internet service provider, the distributor, or the publisher, who up until recent years have generally had unqualified immunity from what users post on their sites. You're talking about Comcast and Facebook being parties to the abuse. And there are dozens of cases throughout each circuit that have actually tried to sue Facebook and sue Instagram and sue Snapchat for causing real harm or enabling or facilitating real harm. So Section 230 of the Communications and Decency Act has been the shield for a lot of these companies, but under recent years, there has been a lot of scrutiny about that because of the rampant child pornography and non-consensual distribution of intimate images that have been able to spread rampant when we know that these service providers and platforms do have the capability to scan and to hash what is actually going on in some of the images or videos that are posted, or some of the hashtags that are used to alert other platform users that some pornography is available. The debate is a really long one between the First Amendment protections and national and personal privacy and security. And I can talk about this all day, but hopefully in a future training, I will be able to. But for now, I just wanted to mention that there are upcoming reforms to Section 230, and there are, the Biden administration, the Trump administration, and the Obama administration were talking about carve-outs for children and other victims of sex trafficking and non-consensual pornography. And if you have been following the latest lawsuits against Pornhub and its parent company, MindGeek, you might be familiar with some of the changes that we're already seeing. So keep your eyes peeled for additional reform for Section 230. And that's a different administrative way that you might be able to tackle some of these under our Privacy Acts and get some of the images removed. So now we'll open it up to you all who we're assuming work with survivors, and to provide us with anything that we might have missed that you might be aware of, or any other legal theories you've tried successfully to pursue on these. And we've seen people be really creative. I've seen a product liability case against a major technology company when someone's child was killed after a stalking and kidnapping incident closely tied to online messaging. So I'm actually going to be quiet for 30 seconds so you all can contribute if you would like.
Please do share if there are legal theories that you've either engaged in or that you've become familiar as a possible way of responding to these types of cases.
Okay. Continue to add if anybody is adding in the chat, but considering the time, I'm going to go ahead and move on to the next slide. So this is something we got into in the last presentation and really in every presentation because it's a cornerstone to trauma-informed and survivor-centered practices, and also tech-informed practices. So the biggest thing is to center the survivor. The victim that you're working with is going to be the most familiar with what's going on in their life. They're the expert of their life, and you've heard that saying or that phrase in the past, I'm sure. So it's important to be thoughtful about how you're communicating with them and how you're trying to gather information from them. Always ask permission for everything. One thing I really, really loved about a recent training that I did with a tech abuse therapist was always talk about consent. If in the age of everything being over Zoom and COVID-19, when you have a meeting with a client that is online or over Zoom, maybe ask their permission of whether or not they want to be have their camera on, and ask their permission if they would want if you can record the the meeting so that they can use it later on, and why you're recording the meeting. Because especially when you're talking about tech, coming from a tech informed lens and a trauma informed lens, it's all about, what is the survivor going through or potentially going through, and how can I make this process a little bit easier on them. So take your time, don't rush, mirror emotions if you can, take time to empathize, try not to sympathize. Nobody likes to feel seriously pitied, or like someone that they're talking to is being super sympathetic. Try to be empathetic, and put yourself in their shoes, with the balance of, vicarious trauma. So I know that it's a lot to think about, but be willing to take over evidence gathering if that's what they need. So constantly ask what it is that your client needs, and how you can be of assistance. One thing I always like to do is educate wherever possible, just to allow my client to feel empowered if that's what they're looking for. So yeah, always come from a trauma-informed approach. Another thing is to be cautious about how you might request or have your client engage with the abuser. Sometimes that will be necessary, especially when there are children involved. I saw that question in the chat earlier. Sometimes it could be more harmful, or sometimes it could be helpful in gathering evidence. So it'll be important to talk with your client about how to engage with the abuser in a safe way, or if the abuser is constantly sending and barraging the survivor with harassing emails, what this might look like is you needing that evidence to help the survivor process the case, but wanting to be a shield for the survivor from suffering anxiety every time they open up an abusive email from the perpetrator. So what that might look like is you set up a forward, help your client set up an automatic forward of those messages to go to a particular folder, and to be sent to that folder to be sent to you later on, or something, so that they don't have to look at it, but the evidence is still being gathered. So here are a couple of basic places that you might find tech based evidence, and simple ways to capture it. We looked at an earlier slide on some of the most common sources of abuse, and the most commonly used platforms for communicating with people. So messaging and texts, for example, how you gather evidence from those is basic screenshotting, or extracting to PDF. I know I say basic because I'm a millennial, but you've seen maybe your grandkids take a screenshot on their phone and automatically save something in their camera roll. That's pretty easy to do, and we're hoping to have another training on going through more of these basic tech-based solutions to capturing information. But if you do know how to take a screenshot, that's one easy way. But you have to make sure that you're collecting information that's going to be useful for authentication purposes. So if you're taking a screenshot or a video of some content that you saw, make sure that it has the date, the time, any information on the sender that you can get, phone number, especially context clues and idiosyncrasy. So if you have a chain of, like a text messaging chain, you can't just include the bad words that the person is using or the name calling. You want to make sure that you, for whole doctrine purposes, include the entire thread, and then talk about what's harmful to your case and what's helpful to your case with your client, so they're also in the know. But what is something that you can actually point to and say that this is the abuser doing this? I know that we're running out of time. I would love to spend more time on this section, especially because of the idiosyncrasies. But just know that some of this might be circumstantial. So it might be an accumulation of things, and maybe not a direct pinpoint of the respondent doing these things, but an accumulation of it in circumstantial evidence, like the fact that they continuously misspell this word in emails and in text messages and in direct messages, might be something that you can point out. Okay. So important next steps when gathering evidence are to try to repeat the information with other people or with your survivor, keeping in mind that having to constantly repeat information is re-traumatizing the survivor. So maybe you actually have to, and we talked about this in our previous training, but maybe you might have to actually set up different times to have multiple interviews with the survivor and cut out specific topics that you're going to talk about, so that they're not repeating the same thing, but you're getting as much information as you can. You might be working with someone who has supportive family members and has supportive friends who would be able to, might be able to remember more details of the abuse, or who also experienced some of that abuse. And for example, I had a client who whose abuser was actually a family member and was incredibly tech savvy, and actually was able to hack, had hacking experience, and was able to hack into the bank accounts of my client and her sister, and actually would print out their latest bank statements and show them to the survivor and her sister. So the sister in that case was able to we were able to help her write a declaration about the abuse that she also experienced. So some of these things are going to be helpful, especially if they're repeated, to boost your credibility when you have someone saying that the client is crazy, for example. Always obtain the survivor's permission before doing anything like that, though. And again, you want to balance what's helpful versus what's harmful, because when you include the entire screenshot and there's name calling going, or the entire text thread and there's name calling going back and forth, you have to talk about how that might harm the case, but how it's helpful to show the pattern or the response that the survivor had after being fed up with this continued harassment. Another thing that we'll sometimes do is when you do have supportive friends and family, is help them prepare for defense interviews or cross-examination. But defense interviews definitely is one that we get a lot. So recording, you might want to take a pause and talk about what is necessary. Talk about trauma considerations and actual rules. So we know that Washington is a two-party consent state, except for certain exceptions. And we don't have time to go into all of the exceptions now, but one of them is to record blackmail or to record emergency situations. So talk with the survivor or the client about recording the abuser and what the options are there and the potential fallout.
Also, just because you can get a recording doesn't mean you need to get a recording. This is why we have the pause up there. Sometimes we get so focused on like how great the evidence would be, we forget what does it mean to put the client in that situation. And sometimes our clients are just so grateful to have an attorney willing to take the case or work on the case. They're also willing to do sometimes whatever to like make the attorney happy. So paying attention to that like power that we have and the kind of requests that we're making, it's really important to be aware of that.
Mm-hmm. You can also do in step 3 your own independent research. If the person's social media pages, for example, are public, don't go adding private accounts, but if it's public, you can go do your own research and take your own screenshots. So that way the survivor doesn't have to go and do all of that work themselves and potentially be re-traumatized or triggered by anything that they see there. If the site has been changed or removed, there's a helpful website, archive.org/web, and then type in the address. It'll show you the historical version of that website, and it goes back really, really far. Another thing is that what's really great about the internet, and sadly what's really great about some of the abuses on the internet, is that you can always find other counter information. So if you have, an email from an abuser and you're wanting to see where it's coming from, maybe they're trying to be anonymous and not use their name, or they've created a fake email, you can always look up or reverse trace the IP address. And like I was saying, the great thing about the internet is that you can literally Google how to trace an IP address. Or if you go to, and all IP addresses, all of the internet traffic is actually embedded within each email. And some of you may have never seen the original view of an email, but if you go to the three dots on your email and you go to scroll down to the bottom, if you're using Gmail, and I wish I had an example of this, and you click on it, it will say show original email. And the original email gives you all of the metadata, including each IP address associated with the coming and going of any message. So you can literally stick that into an IP address locator and figure out where that email came from. And if you have, you can, and it pinpoints the general location of where it came from. There are some encryption services that will make that bounce around a bit, and you might need a little bit more assistance from a technical or a private investigator, and that really just depends on the survivor and what they're able and willing to do in order to gather the evidence. Again, hopefully we will have a training on more of the technical components soon with some of our computer scientists at Techie. But the point is that you don't have to have a computer scientist to gather a lot of this information to use in court.
Danielle, just so you know, we have 10 minutes left.
Oh my gosh, okay. Yeah, let's move on. So I'm going to skip spoofing. It's just another example of tech-enabled abuse. And it's just something that requires a little bit more savvy to get evidence on. So if you come across it, please give us a call and we can walk you through some of it. Okay, so the bulk of this is getting information and evidence admitted. And you just want to make sure that you're submitting things in the right format. Convert it to PDF if you need to. There are certain size caps when you're trying to electronically file something. It has to be less than 5 megabytes. If it's not scannable, one of the most helpful pieces of information we can give now is that you can print it out and fill out an unscannable document cover sheet and file that with the court clerk. There is a filing fee of $30, and you can deliver a hard copy so that it's submitted into the case. Okay, and requests for admissions in civil suits is under Civil Rule 36A. We won't get into that right now, but that's where you'll find what you can actually seek to admit.
Most of the cases that we're involved in usually end up becoming protection orders. So a lot of the civil rules and the evidentiary rules are not going to apply. But if you are working on a civil case where that is not a special proceeding, that and you want to kind of talk through admitting evidence, definitely don't hesitate to contact us. Yeah.
Okay, so again, we're not going to go over evidence rules, but we do have them available for authentication if anybody wants to know. But just in preparing to authenticate, here are some steps that you might consider. Who owns the site? What is it that you're actually looking at? And then again, with that IP tracing, that's one option on how to get at that last thing. Who wrote this post or text? There are ways to get at it is the main point. And sometimes it's going to be a little bit sidestep. So sometimes you're going to have to use circumstantial evidence and look at previous communications with someone. I don't want to leave this slide without giving an example. I had a client who would always call the survivor Mamacita Mia, and every other word was Mamacita or Mama or I got you, Mama, stuff like that. And when they were a couple, before things got crazy, the abuser would also say that verbally in front of family and friends. And so with many declarations from family and friends saying that, this person always called the survivor mamacita or mamma mia or something that's very specific to the survivor, you can have something circumstantial to show that this is an idiosyncrasy that's specific to this person. So we can be more sure when we have a direct message from an anonymous user that this is the person that we're talking about. So again, it may not always be direct. And you'll have to talk with the survivor to figure out what it is that you can actually call on. But that's another thing about the internet is the anonymity, and what kind of gives guts to some of the abusers that we're seeing is that if they don't think that they're going to be caught or identified, that is one thing that fuels them to continue harassing or bullying online. So a reminder for hearsay in tech cases is that, and for protection order cases, well, in protection order cases, hearsay is allowed, but for other cases where evidentiary rules actually apply, here are some of the exceptions. And remember that it's not about the truth of the content. It's you're trying to get admitted, but just to show that it exists. So one example is that just because a text message, calling the petitioner the B word, you're not admitting that to show that the petitioner is a bitch. You're showing it to show that this kind of behavior, this kind of language is used regularly in a harassing or threatening manner. Okay, I want to leave some time for Reedy final considerations. Sorry, I wasn't expecting it to take the time to go that fast.
Okay, this kind of information, like we took a 50 slide PowerPoint and tried to like really jam it into 1 hour. So just so you know how much information that we're really trying to cut down. Some final considerations, like we kind of talked about at the beginning, the law is getting caught up, but the courts, the people within the courts are not necessarily caught up yet. So sometimes with these tech cases, be prepared to educate your bench. Be prepared to really break it down. Simply, what is Snapchat? What is an IP address? Because not only is it going to hopefully help you in your case, but hopefully that bench is now going to be able to identify tech cases when it pops up in front of them, especially with pro se litigants. Pay attention to how evidence is admitted in the court. We have some judges who will not play a video, and so then we have to actually like go through and get screenshots of the video and then file paper or images of the video. We have, the other thing is to really be aware of abusive litigation in tech cases. These are abusers, the same that applies in domestic violence and sexual assault cases. Those same dynamics come into play in these technology-enabled coercive control cases. In fact, sometimes because of the tech access, it's a lot easier, especially with now courts going online, it's a lot easier for abusers to file in multiple jurisdictions, to ask for continuances via email and try to delay the process, to really research all the parties involved, including the judicial officer, including counsel, and try to really bog down the process. This is also where we see abusers engage in the Darvo strategy, where they deny that they've been doing anything wrong or that they've been involved in any sort of problematic behavior, and instead they really hone in on the victim and attack the victim's credibility, the victim's mental health, basically anything that they can attack about the victim. And then the abuser identifies themselves as the victim. They reverse the roles and they identify themselves as a victim in this situation, because it's not a big deal. And then the last thing is really thinking about like the information that's getting admitted to court, that's going to be a part of your case. Often for that legal remedy, for that protection, the victim is having to engage and collect evidence that they want to forget about, that they don't want to be publicly available in a public record. So when you are submitting those text messages that may be very explicit, those images, any information that might be private and related to your client's safety and identity, and long-term healing, wherever you can, making sure to file it under seal to get a protective order. And we listed the case law here in Washington, that the Ishikawa factors that apply when you're filing something under seal in the court of law. So that is really quick. We have a minute left to spare. Are there any other tips and strategies that any of you have been using or engaging with, or have become aware of, that you'd like to share in the chat with us? This is also an opportunity to ask any questions. This is always an evolving area. We're excited to be doing this work. Not only are we excited, but we're also learning through the process. Every case is another opportunity to kind of learn more about how to respond to these types of cases. And so even if we don't have the answer now, we're happy to find it for you. And if there are no questions, this is our contact information. Please don't hesitate to contact us. Danielle and my contact information is at the bottom. But if you do contact us, we recommend by email, we recommend using our legal line email. That way you'll get a faster response, and it also ensures that your message doesn't fall through the crack, because our team is actually checking that email account. But with that, I will actually pause the recording, and Danielle and I will stay on for another couple of minutes in case any of you want to ask your questions offline.